So my problem with Downs is that I've read her judgments, and she's
Okay.
like her previous judgments and the articles that she's written,
Yep. Yep.
and like if you contrast that with what Gorton has done, I've not found a single judgment of Gorton where he has revealed an ability to count beyond 35 or 40 or whatever. So like
Yeah.
his
No,
judgments are,
yeah.
and it's not just us. Like he once wrote an article about how people don't like reading, and that's the truth. And like whether you're making an application to the Court of Appeal or whatever, like everybody will tell you that don't say that or blah blah blah. But the truth is that they will just instinctively make an opinion about you, and so just try to focus on that rather than the substance of the. I'm being a little bit facetious, but that was the essence of what he was saying out loud. Now with her, she's not like that. She's shown the capacity to be thorough, and then
Right.
in our case, she is not. So I think, uh, and the other part is that like I've been before other judges, and um, when I say stuff like the court has no discretion in relation to evidence, it's governed by the Evidence Act, and I cite very technical authorities and uh, provisions. Uh, a lot of them get shocked. She knew that. She knew that completely, and she in fact said, "No, I'm not questioning that. What I'm saying is, like, why should an interlocutory application be heard before? I mean, to say that out loud is patently stupid. I mean, it's not even stupid. It's just there's a level of cognitive dissonance involved that is indicative of the fact that her subconscious biases are taking control. Even in her latest orders, she says that if they don't file the application by then, it's unlikely that their interlocutory application will be heard before the creditor's petition. Like once the creditor's petition is heard, then how can the interlocutory application be heard? I mean, there's a possibility that we may even get unjustly declared bankrupt, and then we can't even sue anybody. That's like the whole point of why they're doing this.
Yeah, no, I understand exactly.
So to say that it'll not be heard before that, I mean, she's not even saying their applications will not be heard or will be dismissed, which would be the honest thing. But she's twisting it then and saying may not be heard before that. Well, it's like it'll not be heard while they're alive, but posthumously.
Silly.
It's just stupid. And to say that like the court will still be just as important and just as busy. So if they think the court is too busy to do these things right now, then I'm sure they will think that what's the point in hearing someone who's already lost and blah blah blah. So what I'm saying is that for her to miss all of those things and to not address, I mean, think about the number of things that she's missed. She didn't mention the constitutional notice in her decision. She didn't mention that I asked for an adjournment. She made up shit about the barrister wanting more time. The barrister was opposed to her delaying the matter or even requiring submissions. What she wanted was the matter to be closed. And so forget about everything else. Forget about the how much she knows. Forget about like what her impressions have been from this or that. The simple fact is this: you read a transcript where two parties have appeared before Justice Stewart of the High Court, and all you know is that the party that had launched the judicial review, the plaintiff, had lost. They had lost at the full court of the federal court, and before that, and then they had lost at the High Court, the appeal, and now they were seeking to what the other side alleged was relitigate the matter through a different mechanism. And the only thing that had changed is that they had received some evidence of the judge's communication with the other side while they were still on. And the first thing that the judge said was, has anyone tried to do something to find out for sure? Like, has anyone, have you directly asked them that? And the guy said no, and then, initially there was no definitive response. Then he asked the other side, like, have they asked your clients directly? And the lawyer said, I don't think so, but I'm not sure. And then the judge said, well, presumably your client would tell the truth, being a model litigant and all that. And the lawyer said, yes, presumably they would. And then the other side came back to respond, and he says, well, you see, they will tell you the truth, so, go ahead and ask, sort of thing. And then he also asked the other side, he said, listen, so the other side was like, this is all decided and blah, blah, blah. So then he said, listen, do you know of any case where there was denial of procedural fairness and it was thought to be irrelevant because it could be fixed by some other opportunity that was given to the other side? And then the guy said no. He says, well, I don't either. It's sort of that thing where, once you do that, he says it infects everything. So
Yeah, and I agree with that.
she was not curious about that. Like, she had that in front of her. She knew what was being alleged. And she was just trying to avoid eye contact. She was not interested in justice. Anyone who hears what has happened is offended by it. Downs was basically trying to avoid, getting into the.
Oh, no. Absolutely. If they can duck and weave, they'll get duck and weave. Judges, that's what they do.
No, I don't think all of them do that.
No, there's a lot of them do. All the magistrates do.
Listen,
They'll duck
a
and
lot
weave.
of you. Okay, what I say, the problem with judges is that most lawyers are dishonest. Almost all people are lazy and also dishonest. And all judges are lawyers and they're humans. So that's going to be there, sure. But so most judges will be useless. But the fact is that we can have an expectation because some judges have set that standard or maintained that standard rather. The standard was set to stop people from burning the place alive because they won't have faith in rule of law. But anyway, that's the problem that I have with Downs. It's not just that, whether or not each thing that she's done is malicious is irrelevant, but I think we can attribute malice.
Wrong. Yeah, wrong is wrong.
Yeah, and we can attribute malice based on what she's done already, because it's also about the area of law she's in. Like, it's a bankruptcy matter. It's 3 people who have very publicized cases. I mean, anyone can see that bankruptcy is not the suitable vehicle for this. What the LSP is trying to do is permanently shut all the allegations that have been made against them.
Yeah, no, I totally agree.
Through this fucking thing. I mean, what will this do? Even if they succeeded, it will just create more drama and more issues for the rule of law. And it's not going to bolster public confidence in their fidelity to their obligations. So, I mean, all the stuff that they keep talking about, like, we want to do this and that, like publish stuff, if we wanted to do, we would have done. But the reason why people do it is because they keep them out of court. So
No, I understand. I understand.
and she's enabling that. I mean, she's a judge. I'm sure she can see that, and that's what they teach them in the judicial training seminars too. So she knows how determined we are. She's read my material. I've made no. I've not concealed or even euphemized the what I feel about Gorton, or and then when she does this, she knows that it's gonna only create more public outrage, but she's just trying to cover for herself, and that's the judge's oath. It's that I will do right by all manner of people. Literally, it's a very short thing, but it says.
No, that's exactly right. It's exactly what they do.
Yeah, so even drug smugglers and horrible people.
Yeah, they all like to be treated, the same degree. Yeah, no, I totally get that.
She didn't do that with us.
I agree. She's made mistakes.
No. She read one side's material.
Yeah, whether or not it's malice, I'm not sure. Only what you're saying in the call.
Yeah.
You can say one thing and say she's pretty silly in what she's done and how she's approached it. With the malice, maybe I don't know. I don't know the answer.
Yeah, no, but I can tell you that if you microanalyze each thing, then it's that, because if you look at each thing individually, sure, you can say that one mistake made, and each mistake may be made independently, but it's the combination of things, and also all of them being lopsided. It's not that she missed any detail in their part, and there's also very clear, like you can clearly see why she did that. It's because I was putting all this material through. She didn't want to read it because then she would know it, and there was no way of unknowing it.
Yeah.
So, and she said as much as well in her thing. And why I still can't understand why she said ex parte. Like, it's the oddest thing, and it's she's a judge. That's the only reason it's not defamatory. But it's but it works both ways, Peter. People are also they have an immunity from criticizing anybody in relation to litigation. Not that anything I say would be defamatory, but they have a privilege against that, and I've went through some cases about it too. So, okay, I'm gonna finish with the thing, and then
early in the morning.
yeah, take care. Bye.
On the way back.
Yeah. Cheers. Bye.
Okay.
Yeah.